attorneys that we work with to a great extent on our H1b petitions, as well as legal permanent residency cases. So welcome everyone. We're pleased to have you with us today. And we're going to have Bob and Debra kick us off.
Okay, thanks, Amy. And just want to say how pleased we are to have this opportunity to talk with you, particularly at this really quite momentous period of time, to try to make sense from an immigration standpoint, what has transpired and what we presumably can expect moving forward for the international student and scholar community. And just want to also just express my appreciation to, or our appreciation to ISSS for inviting us and really trying to create a meaningful service to the community on immigration matters. So let's move forward. So what we hope to do is really talk about, in a way, it's three segments. Number one, we want to talk a little bit about what has transpired over this past period of time and how it impacts international education or immigration prospects for international students and scholars. That's the first thing. Secondly, Debra and Amy are going to talk about some new proposals, specifically in the J and F arena and H1b, that are currently on the table, that are currently under discussion, and presumably in the process of enactment. And then number three, we're going to take a peek ahead to the Biden administration's what we think will be their initiatives in immigration. So looking back over the last 4 years, there have been about 400 changes to our immigration policies. And that is something which is sourced from the Migration Policy Institute, not police, sorry. So it's been an active period. Next slide. But here's what we want to call your attention to. You have 400 odd enactments. And it's important to understand how to classify them. What's the taxonomy of all of these changes? Well, in the US system, you obviously have constitutional amendments followed by statutes. So that's enactments passed by the Congress, signed by the president. Below that are regulations. So that's the kind of instructional sets that the agencies utilize in order to discharge, in this case, the immigration laws of the United States. And the regulations require a process of comment, of consideration by the agency, and then it has to stay within the parameters of the authorizing statute. And then below that would be executive orders. That is, unilateral actions taken by the president to advance a certain agenda. Again, it has to fall within the confines, parameters of the statutes and Constitution. The only reason we're highlighting this, which we'll come back to later, which is if there's going to be fairly large-scale reversal or addressing of some of the initiatives coming out of the Trump administration, the timeline and the method for addressing and various proposals are going to depend on which basket things fall into. So executive orders can be dealt with quite expeditiously. Regulations have a longer lead time. Statutes, which would be are increasingly long and complex. And then, of course, you always have the courts looking to make sure that the system moves satisfactorily, and they will also be weighing in terms of determining whether what we've seen over the past period of time comports with U.S. legal requirements. Next slide, please. And I think, Deborah.
Hi, everyone. So we'd like to talk a bit about what have we seen transpire thus far. So in looking at the framework that Bob has just outlined, we can see that in terms of constitutional amendments, none obviously have been passed. Has Congress passed immigration legislation over the last 4 years? No. But have there been regulatory changes? Yes, there's been a huge amount of regulatory changes that impact not only universities, but the entire immigration structure that we've come to know over the last few decades. Most recently, and what will impact you directly, are some of the changes that have happened to the J1 program and F1 program. And these are coming out through regulatory proposals, and many of them are going to come into play very shortly. We've also seen constrictions in the H1b program, and the H1b is the visa that most professionals work under in the United States. And this, when President Trump was elected, and even during his campaign, he had targeted the H1b program as a means of claiming that the H1b workers were taking away jobs from US citizens. And part of the goal upon his election was to see how can this program be dismantled. And they have done so repeatedly through agency decisions, and also through currently recent proposals on revising the regulatory definitions of what constitutes a specialty occupation. We've also seen, and we'll go into detail, another area of how to cut down immigration is wage reform. And when we mean reform, we mean making wages outside the norm of what employers can pay to make it nearly impossible to sponsor H1b workers. That has been the goal. What they've also added, and we'll go into greater detail later, is a public charge rule, which essentially is a wealth test. They want to prevent individuals who are poor or who have trouble supporting others and may have a risk of accepting government assistance to say, we don't want you in our country. And the proposals have been to put the burden on the immigrant or the non-immigrant to prove that they are self-supportive. What we've also saw were an attack on foreign students in universities, even through COVID, where they had provided initial rules that if your campus was going to go all remote, you couldn't have foreign students. So we've seen huge changes take place in a very short period of time. And Bob will discuss more that have happened.
So what this slide and the next slide does is identifies some of the major initiatives that have been expressed as executive orders or presidential determinations that have impacted our immigration system. And what we've tried to do is to kind of to cull down just the enormous number of executive orders to those that have particular applicability to the academic community. So emanating out of the White House, there have been various directives. And in some senses, the president has a little bit more wiggle room to act in immigration. It's not quite as bound and defined by the Constitution because you don't have citizenship. It overlaps with foreign affairs, with national security, with travel, which disproportionately lies within the purview of the executive branch. So here are some of the things that have had a major impact on U.S. immigration law and policy that have been expressed as executive orders. First of all, we've seen, particularly in April and then in June, whole-scale revisions as to who can get visas, bans on coming to the United States in H1b status or getting green cards. At the beginning of the Trump presidency, you had some fairly draconian constrictions in travel from certain countries. all of that is has to do with visa issuance and who can come to the United States. The conduct of the U.S. consulates, many of the consulates owing to COVID, owing to other considerations, either have closed, have reopened under restricted terms, or have simply ceased to issue visas. One of the more contentious issues, obviously, and this does impact part of the international community in your institution, is DACA, the program dealing with childhood arrivals to the United States. The Congress has not passed comprehensive legislation. It's been addressed initially under the Obama administration, somewhat as a piecemeal stopgap measure. It's certainly fallen within the crosshairs of the Trump administration. There's been a program, TPS, and again, some of your scholars may be from countries that have been experiencing civil disruption, and the United States has extended protection under something called temporary protected status. That many of the countries are being decertified, and the president's right to do so has been largely upheld in the courts. Certainly something that has been quite prominently discussed in the media is our whole southern border policy, the Remain in Mexico policy, family separation, restrictions in access to asylum. Again, those are pursuant to executive orders. And something which we'll be coming back to is something called Operation Optical Illusion, directly focused on the academic community, in which ICE, Immigration and Customs Enforcement, believes there is rampant fraud and abuse in work authorization under the optional practical training. And they have launched a particular investigation, an enforcement action against students using OPT. So again, it's something to keep our eyes on. Next slide, please. And other things that, again, we think have disproportionate impact within the academic community is, first of all, an increase in premium processing fees. They've gone up to $2,500, which is quite important given the extraordinary slowdown in processing of petitions. So realistically, if you want to get a final decision within a reasonable period of time, you've got a premium process. So again, this is going to be a budgetary hit to you. There's a new program in which Chinese scholars in particular are being profiled and singled out. And if they have a background in dealings with what's known as the military fusion strategy in China, they become inadmissible to the United States. And there have been a number, and I don't know if there have been any at the University of Colorado, Denver, but Amy's shaking her head, yes. In fact, I kind of remember that, again, some of the Chinese scholars have fallen within this proposal. One of the things also that we've seen has been new requirements if someone is changing into F1 student status, and it expresses itself in the following manner. The application to change status, the processing time can really take just an inordinately long period of time. We're talking 6, 7, 8 months. And the new policy, and it used to be that once you filed your application, the student was at least allowed to stay in the United States. Now they need to maintain an underlying status during that whole period of time. One of the things which we've seen, which is really added a great deal of instability in the immigration process is a rescission of the deference policy. That is, you use, let's say, one of the currently used non-immigrant visa classifications you use is O1, extraordinary ability. And the policy had been that once someone was approved for O1, there would be a presumption that extensions would be granted unless there was material change or fraud, which rarely happened. That's been rescinded, and now for extensions, even from previous approvals, be it O1, H1b, there are no shortcuts. You have to start the whole process all over again to sustain your burden of proof. And it really has added a great deal of uncertainty. There's also been the adjustment of status interview requirement, where it used to be the green cards in employment-based cases were largely issued without the need of a personal interview, rather based on a review of the paperwork. Now your scholars need to show up at the local office for an interview. And then there's also been a new proposal that links in the H1b lottery. So in situations where your scholars are leaving the academic community, going into private industry, and there are too many H1b petitions for the quota, it used to be there's a random lottery process. Now immigration is saying, we're going to allocate H1Bs for the overage based on what is the salary being granted to a position. And it will have an impact of disproportionately penalizing, first of all, junior professionals, and also many scientists in the where the pay scale may not be quite as high as in some other sectors, but it conceivably will have some extremely deleterious impact on putting your scholars in a suboptimal competitive position in getting H1Bs under the lottery system. Anyway, those are just some of the things that have been enacted and implemented pursuant to executive orders rather than a more formal rulemaking process. Debra?
So as you can see, we announced there are 400 changes, and we've only given you about 10 to 15 of them. So you can see what kind of last 4 years have been. So what up until today, here's where the world of immigration has been. I apologize, my cat is deciding to scratch the walls at the same time. The goal that we have seen is to curtail family immigration. And so part of how the administration has prevented families from joining each other is one, through travel bans. They've prevented immigration, even for those who've sponsored them based on being from a certain country or nationality. The wait times have grown tremendously in terms of processing. And after COVID, they've done bans that prevent you to get an immigrant visa from outside the country from most embassies. So that's cut down on family unity and benefits. Another way they've also harmed families is by the public charge rule. If you're a family that earns under the poverty level guidelines, they've made it nearly impossible to sponsor a spouse or child or parent to come to the US to join them. They've also done an end to humanitarian benefits. As Bob has discussed, they ended temporary protected status, which is mainly for war-torn or regions that are unable to allow their nationals to return home because their country can't accept them safely based on a variety of circumstances. They've also attacked asylum, right? We've heard proposals where the administration believes most people applying for asylum are committing fraud, right? They want to come in for a work card, eliminating the true concept of what it means to have signed the Refugee Protection Act and apply our laws fairly to those who are seeking it. We've seen a huge increase in enforcement, not just the border wall, but in actually funding immigration and customs enforcement and customs and border protection, where they've been given tremendous funding, resources, weaponry to enforce the border, but also within the US as well. The USCIS, which is the agency that adjudicates most benefits, has the authority to issue notice to appear. So if they not only deny your case, they can then put you in deportation proceedings to have to put you in front of a judge. So they've created an agency that's supposed to be the adjudication factor and giving them enforcement powers. And what this has done overall is decrease legal immigration just as well as it has illegal immigration. They've made it much more difficult for employers to sponsor foreign nationals, for students to come into the United States. It's more difficult to even get a visa to come to the US. And so it's made what had been a welcoming country where most people in the world want to come work or study or travel to, we've put a do not enter sign. We've vetted who we believe should be allowed to enter the United States. So in talking about some of these components, I thought it'd be helpful to talk a little bit more about what we've seen come through the administration in terms of travel, because this is something that is still ongoing. Many of you were aware of the travel bans. We saw protests in the streets at the airports where it was first laid out. There was actually 3 iterations of the travel ban, and we've listed the countries here. Not all of them have the same type of ban. Some will still allow J1 or F1 students. Some are only immigrant visas that are banned. But the overall what unique factor most of these countries have in common is they tend to be of high predominant Muslim population, or countries where they have seen abuse of the immigration system according to the administration, where the people have overstayed visas. And I can say here in Minnesota, we have a very large Somali population. And when the travel ban came in, individuals have been basically separated from their family now for well over 3 years. We haven't been able to bring over a spouse. You can't bring over parents. 0 visas are being issued. While there is a waiver process, it's been very rarely utilized, and it's been very sad for many of these countries. And the presidential authority to do so was upheld. And so what did this lead us to? Well, now we have new travel bans, right? Under the guise of COVID, where some may have some foundation in science to protect and limit the spread of a devastating disease, many of these were also used as an excuse to ban immigration in terms of protecting our economy. And so we did start seeing bans that came out. The first one was China, and then Brazil as their numbers went up, and Iran, and now we have one basically for most of Europe. Now, we can decide whose numbers and whether US is even higher than any of the countries abroad, but the ban in place has imposed essentially a 14-day quarantine before you can enter the United States. So if you want to travel from Spain, for example, you can't come into the United States without first being outside of Spain for 14 days before you come into the US, unless you get a national interest exemption. And this is for individuals who have work authorization or F1 student visas. You'd have to apply for an exception. There was also a ban for anyone outside the country when this travel ban was into play, that they could no longer get H1 or L1 visas to come into the US, even if they already had an employer in the United States and had merely been on vacation. The exemptions to many of these have been very limited to those who have US citizen spouse or children or permanent resident ties, but it's extremely curtailed the ability of individuals to travel, get visas to come back to the US. It's also impacted immigrant visas. In many ways of getting a green card holder, people can apply for adjustment of status if they're in their US. Otherwise, you can apply for an immigrant visa directly at the US Embassy in their home country. An immigrant visa abroad has essentially been curtailed for almost all employment-based cases and through the end of the year, December 31st. We haven't been able to bring over almost any immigrant visa. And so you can imagine that's a large volume of individuals who had planned to make the US their permanent home, right? To come in, who've gone through all the process, have followed all proper procedures of legal immigration, and have essentially been banned. And we also saw embassy closures around the world, and this is still in place. We didn't see a slow reopening until end of July, August, and it's different from country to country. Some are dependent on, travel restrictions internally within the country, and others are operating at a very slow basis. It's not their priority to help provide for visas, and so travel restrictions for academia are still very worrisome, because there's the risk that the embassy could close at any time. And even getting visa appointments has become extremely difficult. And so what else did we see? We saw, fortunately for students, initially they were subject to the ban and couldn't get in. And then they realized, why, school's starting. Okay, maybe all these students have paid fees and have I-20s and are ready to come over. And they were providing that one of the exemptions you could see on the website is to say, if you're a student, tell us, we'll try to get you a visa to allow you to attend school on time. There are national interest exemptions. So if you qualify, for example, medical personnel, if you're a physician and you're going to be pretty much most fields, if we can tie it to providing necessary care in the United States, we've been able to secure visas. If you have a huge economic interest where you can show you're working, for example, with manufacturing, or the work that you do is in creating other jobs in the US, you can apply for an exemption. But the exemption is only for a one-time travel within 30 days. So there's also extreme limitations on what you're allowed to come in. And then again, please keep monitoring for embassies to reopen, because it is going to take some time for individuals to come back to the United States.
Okay, we're going to switch over to talking about a major new development, and this really affects your institution, academic institutions of higher education. And what it is, it's a proposal to revise substantially some of the fundamentals in the F1 student visa situation and the J1 exchange visitor classification. And I want to kind of sketch out a couple things that it states, and then Amy will be talking about really how does this impact you, how does it impact her office, how does it impact your students and your scholars, okay? So let's go to the next slide, Debra. Here's what the rule in essence does. Going back to 1980, the way that students were admitted to the United States, and right around that time, the same process was applied to J1s. Rather than tracking students and scholars on a year-to-year or a time-defined basis, when someone comes in, the student would be granted duration of status, which basically says as long as a student is making satisfactory progress, usually as a full-time student toward degree completion, they are maintaining their status. And same with the J1s. They're granted a period of time called duration of status. Again, it's open-ended, which says that as long as they are complying with their J1 obligations, they are maintaining status. They're legal. Well, then as time went on, starting in 1996 and really taking shape in the immediate aftermath of 9/11, the monitoring agency or the monitoring entity was vested in the universities through the SEVIS program. And so what SEVIS does is it basically creates a database in which for students, the designated school official, and for the J1s, the RO, the responsible officer, really is in charge of monitoring, maintaining the database to ensure that people are working in line with their visa status. And what is now being proposed is the following. Rather than allowing students and exchange visitors to come in under duration of status, they will now be allowed to come into the United States on a time-limited basis. So basically, it's for as long as up to 4 years, or as long as up to 4 years is the period of time that students are allowed to come into the United States, or that J1s are allowed to come in initially. And anything beyond that, and actually it's 4 years in general, unless a student or exchange visitor is from either a country, a state sponsor of terrorism, or from a country that has significant levels of overstays, in which case it's only 2 years. And then what happens is the student or exchange visitor needs to apply for an extension to U.S. Citizenship and Immigration Services, USCIS. It still goes over the DSO or the RO's desk. There has to be a recommendation, but the ultimate determining authority becomes not someone grounded in the academic world, but rather a U.S. government bureaucrat, an immigration bureaucrat, who's going to be making decisions on, is a student maintaining appropriate progress toward degree completion. And it creates a whole bunch of new limitations on just the flexibility and the fluidity of the student experience, and for that matter, the J1 exchange visitor experience. So, for example, a student can only go 2 times at the same degree level before being denied. They can only go 1 time if they have to go back in time to get a degree at a lesser level than what they're at. It raises some significant issues, very frankly, in dual degree programs. And very frankly, this 4-year limitation is simply at odds with the normal period of time that's required for degree completion. I mean, international students do better than their U.S. counterparts, but statistically, it's 4.69 years is what it takes an international student in the United States to get degrees. PhDs take 5.3. Dual degrees, 7.5 years is the average normal period of time. Could USCIS approve those extensions? Yes. But it injects a great deal of uncertainty, a great deal of instability, and a great deal of delay in the whole process. It has tremendous unsettling prospects within the entire international student and scholar community. And that's the problem. That's the problem. That is, it's a reflection, as much as anything, of a changed attitude toward the value of attracting international students and scholars. I mean, we've seen, by the way, just parenthetically, over the past 5 years, there's been a decrease of 43% in the number of international students coming to the United States. That's just a fact. So, and then what the new rule also goes on to say is it made some major impacts in employment status. So what it says is that if a student is working for on-campus employment and they file for an extension, they get a 180-degree extension of their employment. Okay. So, and there is, by the way, some question of if 180 days is enough given the inordinately slow periods of time to adjudicate extension requests. But then what happens if someone is working in curricular practical training, CBP, CPT, sorry, I need another cup of coffee. So, you know, this is kind of your internship situation. Here, there's no extension. So you need to get the approval of the F1 in order for the student to continue to work in CPT. In terms of OPT, so that's kind of the, you know, experiential learning process. Here, the student has to apply for an extension of F1 and put in their application for the employment card. And it's only upon the approval of the extension and the issuance of the employment card that the student can start working in, you know, post-completion OPT. For example, in the J1 schema, they get 240-day extension to continue in their program. So there's a little bit more flexibility. But again, what you have is this injection of a bureaucratic process into some fundamental decisions that probably would be best decided within the academic community. And it's not as if SEVIS is impervious to government inspection. The government can, at any time, look into the SEVIS records at University of Colorado, Denver, and make a determination if someone is maintaining status or if they have questions or whatever. So it is not as if it is a program resistant to inspection. But here, on a proactive measure, you've built in this system that interjects or injects government bureaucrats entering very deeply into the educational experience or the scholarly experience of your international community. And it's not just a question of the capabilities and sensitivities of government adjudicators, but it's also the bureaucratic hassle, the additional expense, the inordinately long periods of time to render adjudications. All of those are clear signals that we're no longer have such an organic, fluid, receptive, sustaining type of a system. And it's really something of major concern. By the way, one thing which I forgot to state is that not only are the periods of time granted to international students and scholars limited to 4 years, again, subject to extension, but the grace period, which for 40 years for students had been granted for 60 days is now being reduced to 30 days. Now, this rule, by the way, was issued. It had a comment period, a 30-day comment period, which closed on October 26th. I think they received literally thousands of comments, including from state attorney generals, including from Colorado, the educational consortiums, universities, and for that matter, industry weighed in very, very heavily on just how this is such a disservice to maintaining the talent pool required for economic development and scientific development. Amy, how does all this work as you see it? Obviously, we're working through things, but how does it work with your job, with your office, and what do you anticipate?
Yeah, I mean, I think the question that we have on our minds in ISSS is, when would this take effect, right? I think right now we're looking at travel for our students and scholars. You know, a lot of them are thinking about traveling back home for the winter break. And so we're doing a lot of advising currently on that process and whether that's even possible during COVID. But then also, you know, they have a lot of questions about, first of all, if they'll be able to get back to the US, if, you know, depending on what's happening here. And you know, within our team, we are at various levels having conversations with students and scholars about the possibility of a fixed end date to their records when they get back to the country. You know, I mean, we just don't know when this would take effect. And so we're trying to have realistic conversations with people, but at the same time, it is a proposed rule. And so it is challenging to talk about, and especially since we don't know when and if it will take effect. But my prediction is that it would probably take effect sometime at the end of December, early January, and that's exactly when our people would be traveling potentially back and forth to their countries. So I think that's what's top of mind currently with regards to this change.
Right. This is a game changer. This is a very disruptive game changer that's going to require a great deal of gymnastics, very frankly, and pre-planning by students, scholars, departments, ISSS, the whole ball of wax, and then how it all plays out. And that's what's quite unnerving, very frankly, because literally for 40 years, 50 years, the United States has been the predominating destination for international students. And it's, you know, on multiple levels, it's been such a wonderful attribute of our country, of our social structure, of our economic development, you know, and to see this upended. And then we'll be getting quite soon into, Deborah's going to be talking about H1bs, which again is in terms of having a student or scholar charting out a long-term trajectory when they start out with instabilities in their student experience or the scholar experience, and then face restrictive quotas or restrictive adjudications, restrictive salary levels that you know, it becomes more and more daunting. I mean, again, as a country, we have marvelous attributes leading you know, international scholars and students to seek experience in the United States. But at what point do we use up our goodwill? I mean, Canada has experienced a 15% increase in their foreign student enrollment. The question was asked, who's issued the proposed rule, and how does that get decided and promulgated into a final rule? It falls within the Department of Homeland Security, and in particular, the notice of proposed rulemaking came out of U.S. Citizenship and Immigration Services. Was it, or was it ICE? I can't remember. I think it was USCIS. It's Department of Homeland Security. So here's what goes on, and this kind of plays into, and I agree with Amy, that right now it's proposed, lots and lots and lots of comments. My own expectation is that it will be implemented in a very harsh manner under the current administration. And then we'll talk a little bit longer about what's the steps, what's the timeline to reverse it under a Biden administration, but it's not something that can be done overnight because this is a regulatory provision. So it's not as if you have, it can be undone with the stroke of a pen. It has to go through notice and comment and formulation and all of that, which simply does not happen overnight. Okay. Amy, have I missed anything in terms of the high points of?
Well, I think, kind of going back to your question earlier, Bob, another thing that we are discussing with students and scholars currently is, and with departments, is there a possibility of extension or is there a need for extension of their programs? Because if we're able to get the extension in now before this potential rule change takes effect, we could really alleviate some of the challenge later on for some of our students and scholars. So I think that that's a main point that I want to make, is that if you know that your scholar's end date is approaching within the next year even, work with our office to get an extension in now, if possible, is what I'm recommending.
Yeah.
The other thing I would mention is that ISSS did also submit comments. There were 30,000, I think about 30,000 comments that were submitted for this rule change. And ISSS worked on a very substantial 19-page response to the comments, actually, and had several departments that contributed to that. So I wanted to say thank you to everyone who contributed to our comments. Yeah, it's a monumental change, really. And
the academic community is really, really pressing back on it. But then the issue becomes, particularly in a lame duck situation, how responsive is the administration to external input, because they don't have to experience the consequences politically. And look, they're pretty ideologically committed to a very constrictive immigration policy, and they have not been, at least on an immigration front, a real friend of the academic community. So again, my own call is, regardless of the volume of comments, we're going to see a final rule that in large measure resembles what we've talked about. Okay, Debra, I think you're on another aspect of major concern.
Well, on that happy note, let's talk about additional changes we've seen, also proposed, that is also published in the Federal Register as of next month. What has come out is kind of a frontline attack on immigration from the legal perspective. So it started out looking at students, right? How to prevent foreign students from coming to the US, limiting their studies, limiting their ability to work after graduation. And now they're focusing on, okay, what about all these individuals who are coming to the US to work? Prior to this rule that's been proposed, the agency had been attempting to attack the H1B through denials, through requests for evidence. We've seen, I think, almost a 70% increase in requests for evidence on H1B petitions, and a denial rate that's gone up over 33%. This is really unprecedented. I know we could even count on a hand of just how few cases we had ever had denied, and all of a sudden we were being challenged right and left on regular petitions, right? Nothing challenging or unique about it. And we started seeing patterns of what the agency was doing. And I give them credit. They were very smart. They were looking at what were the weaknesses in these petitions and how could they try and find a path to deny them. One of the key area they focused on after losing, well, really they took two approaches. One, they tried to target the labor condition application to focus on the wages. So what they did is they started denying petitions and said, if you're applying a level 1 wage, which would be an entry-level wage paid to new hires, they were saying that doesn't count as a professional position. It's too much of a trainee and shouldn't be considered a specialty occupation. Well, they lost on that over and over again because it didn't match the regulations in place. So then they started targeting specialty occupations, which is essentially the H1B is for individuals working in positions that require at least a bachelor's degree or higher to perform the job, right? So something that a college graduate is going to consider a professional level position. They started attacking nearly all occupations. I mean, we even saw RFEs for doctors or dentists saying, prove you require a bachelor's degree. I mean, these were some ridiculous challenges to the law. Well, employers kept suing, right? They said, we're not going to stand by and allow these denials to happen. We stand by our position that we'd only hire bachelor's level educated employees. And immigration and the agency kept losing at the courts. And so they said, all right, we're losing because the law is allowing these petitions to go forward. So let's change the regulations. And so that's exactly what they've done. They have now proposed new regulations that have really narrowed the definition of specialty occupation. And so what this means is they're now redefining how you prove a position requires a bachelor's degree. Essentially, they're saying it can't be any bachelor's degree. It needs to be in a specific specialty, right? Your specific field of study that qualifies you for the position. So for example, they had always thought engineering is much too broad. If you say you accept a mechanical or industrial engineering degree, they may say, no, that's too general. Obviously, you accept any type of engineering degree. We want to see it specified. And what they've also done is said, how do you prove that a particular degree is required? It's no longer enough to say, well, this is what we've always required. They want you to provide secondary evidence that proves that it's normal to the occupation and the industry to require a specific degree. And so they've often used what's called the Occupational Outlook Handbook to define that scope. And that, of course, has also been changed, where they would use terms like it's normal to the occupation. And they've now said that's not enough, right? So if it's normal to an occupation to require a degree, and that level is no longer enough to prove it, they've really narrowed the standard and increased the burden of proof to define what's a specialty occupation. So if this goes through in December, we believe it's going to be much more difficult for many occupations, particularly in the field of computer occupations, or emerging fields, right? If you're in data analytics, if you're in numerous newer fields of study that don't have a lot of data because they're just coming out with these new positions, it's going to be very hard to prove these cases. What they've also done is looked at worksite location rules. And one would think, why would that matter, right? If you're controlling your worker, where does it matter where they work? Well, it's really because of the consulting industry. This isn't going to be as a huge of an issue, to my opinion, for the academic community, but what they're doing is attacking the H1B program due to the entire IT consulting company. Essentially, they're saying if you're an employer and your employee is at a third party, we don't truly believe you're really their employer in sense of monitoring and evaluating the employee's work. We're going to limit your H1B to 1 year, right? So what does that require? Numerous filings after filings, increase fees. They've also redefined who is an employer in those circumstances. In a sense, trying to articulate that if you are a consulting company and your employee is working for a third party, how do you prove you're really evaluating their work, and can you prove they're actually performing specialty occupation work? The new rule also provides for increased site visits and enforcement. So that means if you've said you have a research assistant working in the lab, they can literally show up at the lab and ask to see where to talk with your employee, to vet them, to ask what they're actually doing on a day-to-day work at their job, who's their supervisor. They may ask to see the public access file to confirm the information that was presented in the H1b is consistent with what was filed. And they may look at wages. They're going to say, well, how much are you making? And if we had put a level 1 entry-level position and they think the person is working with independence and actually supervising other employees, they may challenge the H1b. And this is the entire goal of the regulation, to really allow for the agency to come back when they want to make it much more difficult to sustain the H1b program. And as we had mentioned earlier, they've also proposed changes to the H1b Lottery, which fortunately for the university, you don't have to worry about it being an exempt employer, but it makes a difference to your students who graduate. If they're out on the market looking, they're going to have a very difficult time securing an H1b in the lottery, because recent grads are going to be most likely entry level, right? They're coming in with not a lot of experience. And they're looking at a 4-tier wage scale, and they're saying if you're level 4 in that occupation, you have a better chance than someone level 1, which really means they're looking for people with master's degree, people with 5 years or more experience. And when I get to wages, you're going to see how that's nearly impossible when you see the new wages that have come out. But what happened in conjunction with the H1b changes? They also created new wage levels by the Department of Labor. And the wage levels are used for both the H1b program and the PERM program. So for the permanent residence of workers and for the temporary employment of workers. And this rule was they not only proposed it with a 30-day period of notice and comment, but they implemented it immediately. So this began on October 8th. My birthday. I said they were so kind to give me 2 very, very unfortunate rules. And what did we see? A dramatic increase in wage level. So the OES wage levels are essentially what's considered a safe harbor. So if an employer uses the wages posted by Department of Labor, they're considered to be in compliance with their wage requirements. And many of you know who work with our office and work with Amy's office, you already create your own actual wage memo. We know that goes along with our H1b filings. You've done your own analysis of your employees and that occupation, and you usually have a very solid wage scale that you know, and that from associate professor to this level, these are the wages that you pay. Those may not carry any more weight under these new rules. They've essentially increased the wage scale by an amount. I just wanted to bring up my statistics. Sometimes I get to be a geek with some numbers. And so the entry level, so this would be someone who's just starting out in your position, has increased to the 45th percentile. So that means you're going to be paying an entry-level worker at about half the wage rate of someone who's been in the position for, half their wage scale. And then it goes up to the 62nd percentile, the 78th percentile, and the 95th percentile. And what those numbers mean is that wages have gone up. We're looking at $20,000 increases per level, well outside the norm of what is market. And what also happened is that in reviewing their new wages, occupations often no longer even show up. And so Amy, maybe you want to talk a little bit about the analysis that your office did in looking at your current H1b workers.
Yeah, so between the University of Colorado Denver and Anschutz Medical Campus, we have currently about 160 active H1b employees. Out of that 160, 70 of them, if we had to file today, would not meet the new wage requirement for based on this Department of Labor rule. So in that assessment, we also saw that there were a few codes that we traditionally use within the OES, health specialties teachers post-secondary, as well as physicians and surgeons all other, which do not have any data at all for our region within the Denver MSA. So basically what we're looking at now, which is your next bullet point here, is salary surveys. And Debra and I are meeting with some central HR colleagues to discuss what that might look like for our institution. So we are taking active steps to try to sort of resolve this issue for our H1b employees, knowing that most departments currently, there's no possibility of raising someone's wage due to COVID and all the other issues that we're currently experiencing at the institution. So we are actively looking at solutions currently.
Thank you, Amy. So the good news is we're not giving up, but for the immediate need for those we're filing H1b extensions for right now, so far we're doing okay, but there's going to be some cases that are going to be put on hold a little bit till we resolve the wage issues. When they created this rule, they did not eliminate the allowance for businesses to use salary surveys. And essentially that's using a private wage survey. So I know the university subscribes to about 8 different surveys that they purchase when they do their compensation analysis internally. And so we're hopeful that many of those surveys we will be able to use for our H1Bs. Right, that we're going to find an acceptable wage that meets those levels. And there may be times where we don't have a survey. There's certain industries or occupations, there's just not enough data, even in the private realm of review, where it may not be feasible any longer to file an H1B for someone. Which brings us to litigation. Okay, so if you can't use the system, so the wage scale, just to let you know, has been in place for well over like 3 decades. I mean, this is a huge change. This has not happened. I mean, the biggest change before was going from you needed to pay 95% of the prevailing wage to 100% of the prevailing wage. I mean, okay, 5%, people were fine with it. This is just a dramatic. So there are 3 lawsuits. Many, I will say, of them, universities have taken a strong stand. Because it impacts them specifically and directly, and have extremely important researchers, scholars, physicians that are employed that need to be able to maintain those employees. I believe there's a temporary restraining order hearing going on the 13th. So I'm always an optimist, but I believe we are optimistic that there may be an injunction, which would bring us back to old wage scale. So we're hopeful in a few weeks that maybe this will be resolved in litigation. But this is absolutely something that's going to need to be resolved by the next administration, because to us, this is one of the greatest challenges to the H1B program, because this brings in, you have to pay wages, and the fines and penalties when you sign an LCA for wage, then you bring in Department of Labor audits, wage and hour violations, and then it creates a huge influx of attacks for any employer using the program. Did we tell you this would be such a light conversation? So, what does this mean? We're seeing, obviously, this administration has encouraged a policy of no, right? If they can find a path to deny, they're looking for one. As Bob had referenced, this meant no deference to prior approvals. This, to me, is extremely challenging because people have spent their lives here. They may have been working for you for 5 years, 6 years, or been in an O1 for even 10 years. And all of a sudden, when they have to do a renewal, they worry their entire future could end based on one small adjudicator sitting in Texas or Nebraska. And that shouldn't happen. You should have some certainty in knowing that you've already proven your case 3 or 4 times before. You should have some certainty that it should be approved again, and that's no longer the case. Again, requests for evidence challenging your petition has increased tremendously, and we've seen a huge higher increase of denied cases than ever before. And then the cost. We mentioned premium processing fee has now greatly increased, but they had attempted to raise all of immigration fees, and that was prevented by a federal court who enjoined the new fees. But I think that's something to have to keep in mind. Immigration is self-funded. It's funded by the individuals using it. And when the agency uses it for enforcement purposes, for vetting, for fingerprints, and not for adjudication, it cuts down on people applying, right? And that's what we've seen cause a lot of these issues. Real quick, I'll talk a bit about the public charge. We've discussed this. There's always been a public charge rule. Essentially, the biggest difference is they're now requiring attestations to it, and an incredibly detailed form and documentation. So if you file to sponsor someone in H1b or file even a change of status petition, the individual must attest that they have not accepted public benefits, or if they have to describe and provide the documentation, and the agency will do an analysis if they believe they're at risk. This is regardless of their employment and earned of income in the US right now. If they want to file for a green card application, there's a new form called the 944 that requires an individual to provide their tax returns, to provide their credit report, to provide 12 months of bank statements, to provide their health insurance evidence, to provide their entire net worth in terms of assets and their liabilities. They have to disclose if they ever filed for bankruptcy. They have to provide evidence that they speak English. They have to disclose all dependents in their family, and they do an evaluation test. So it's, you feel so judged. It's not as if you're applying for a credit card, you're applying for a green card. And there's an entire evaluation as to whether they believe, essentially, are you worthy of getting a green card based on your financial, how well you balance your finances and have the possibility of contribution. And so maybe for university employees, this is more of just a painful paperwork process. But for individuals on the cusp, I mean, many of your research associates don't make a lot of money and they have families to support, and many of them could be on this cusp. This could be the difference as to whether they can get a green card or not. And so this is also a rule we hope will go away because, in my opinion, your worth or value of becoming a permanent resident or becoming a citizen shouldn't be dependent on the amount of money you have in your bank account. I digress.
Okay. Oops.
Oh, I'll just mention for DACA quickly, as Bob had already mentioned, Deferred Action for Childhood Arrivals. It came out by President Obama. I remember I cried that day. I was so excited that there was some reform and benefit to individuals. And then it was rescinded by the Trump administration. It went all the way to the Supreme Court, who said that rescission was done unlawfully. But yet there's still no new applications for DACA. It's now been limited to 1-year extensions. At the time of writing this, it was an uncertain future. I think Biden has come out to said he will extend DACA and bring it back. Whether it will be extended to allow for new applicants or only those already grandfathered in, we don't know. But really, it's under executive order. And as we've seen, through the stroke of a pen, it can go away. And so this is an area that does require congressional reform in order to actually provide a long-term benefit, and that remains to be seen.
Okay. Look, I feel that we've been experiencing a little bit like a Hieronymus Bosch painting as we go through just kind of a litany of horrors. And it really is concerning to the academic community. So what this slide does, and by the way, we want to reserve some time for Q&A, so we want to run through the balance pretty quickly. But there is the kind of a pervasive agency culture that has been developed over the years, and it kind of works its way back in some of the things Debra was talking about, the culture of no, but also so many of your petitions involve an exercise of discretion, determining is someone, and for permanent residents, is someone an outstanding academic figure, is someone extraordinary. Those are protean terms. They can mean different things to different people, and it's really that exercise of discretion that's become quite problematic. So that is kind of where we are now. Next slide, please. So we want to talk in this final stage on what can we expect, what should we expect from the Biden administration. And again, this goes back to that slide at the very beginning with the taxonomy of the kind of all of the new immigration policies, procedures. So what can Biden do under executive order? That is something he can do unilaterally. What requires an agency to develop new regulations solicit comments, consider the comments, come out with a final rule. It's a much more extended process. What are the prospects for comprehensive immigration reform? Again, that's the whole ball of wax. That goes to the Congress, signed by the president. And then what can we expect in terms of changing the culture? Okay, next slide, please. Tier 1, what can or should we expect from the president, from Biden, on his own initiative? Obviously, this is speculation, but I do think that we're going to see just a slew of kind of humanitarian reforms. He staked a good part of his candidacy on being a humane, both individual and public figure. He's gone on record of saying we can expect a revitalization of the refugee quotas, which now stands at 15,000. He wants to take it to about 125,000. And you know, all of the kind of a slew of things we saw under the current administration, I think Biden will address quite directly. I think he's going to do something with DACA. I think he's going to try to create some type of stability for childhood entrants. He's definitely going after the travel bans. In fact, I think that he's actually made a public pronouncement yesterday of an intention of eliminating country-specific travel bans. One of the things that we've seen in the realm of immigration enforcement is really, it's a criminalization of those who are in the United States without authorization, rather than a prioritization. So it used to be that the government would really go after individuals who had, you know, either overstays or those violating, if they had created problems with the law. I think he's going to go back to that to really kind of focus on getting rid of the quote unquote bad actors, rather than doing a broad paintbrush of anyone in the United States without authorization should be charged criminally. And I think that we're going to see some major revisions in public charge, which is what Debra was talking about. Debra? I think
Sure.
this is yours.
It can be, sure.
Go for it.
So again, this is about the regulations, right? These were the programs that Bob and I and Amy have been discussing on changes to the F1J1. Again, if that does pass, I'm fairly certain there will be a reversal, right? There'll be new rules proposed to bring back duration of status. It was so widely opposed by almost every academic community center there is. There may need to be some reform on OPT. I don't doubt that. There have been some fake universities who basically allowed complete online programs just to give OPT, but it's very simple to crack down on a few bad apples and not harm an entire program that's worked well. The H1b, again, industry, our tech industry is greatly injured by these changes. So there will likely be new rulemaking to go back, but it will take time. There's still going to be a vociferous court challenges to many of these rules, and we may see them come into play at court. Again, the hope for congressional override, you know, depending on what happens in the last two Senate races, I'm not optimistic we'll see much in the terms of Congress being able to enact anything. So it may be back more on tier 1 than we see for tier 2. But Bob, you tell me if you think it's optional. Yeah,
but we changed the numbering of the slides. That's the okay. Comprehensive immigration reform. That's been an elusive goal. And I think the last time there was a submission of a comprehensive immigration reform package was under George W. Bush. So, but I think that one of the things we've seen over this past period of time is that immigration has become a front burner issue. And with that goes a greater impetus and a greater likelihood of actually getting some reform, although given the anticipated composition of the Congress, becomes somewhat more doubtful. But were there to be comprehensive immigration reform, to the extent that it would be driven by Biden, I think that what we would see is, to be sure, dreamer legislation or earned legalization for childhood arrivals. Our immigration laws are particularly in the employment sphere, are they're really out of date. We're too constrictive in our quotas, and things like per country limitations on visas. So if someone is from Pakistan, a physician normally can get a green card in about 18 months based on employment. If they're from India, it's 12 plus years. And there actually have been some proposals in the Congress to eliminate it's a 7% cap on sourcing green cards from any one country. Certainly, is there a need to raise the quota for H1Bs? That really gets into what are the values, what's the value of H1B temporary workers in terms of, do they take jobs or do they contribute to the overall US economy? And there's some very, very compelling data suggesting that H1Bs, create jobs, add to the national wealth, and so on. So again, whether it will be reflected in comprehensive immigration reform, could be. And then there's also been at least some proposals to give green cards really to PhDs in STEM disciplines. Again, it goes back to simply a basic fundamental reality that when it comes to immigration, there's considerably greater possibilities, unconstrained from a lot of constitutional constraints, for imagination, for creativity, for really figuring out what is immigration, how does it impact the national welfare. Debra?
And at the end, what we hope the change of administration will do is maybe make immigration less a partisan issue and more about why we are a nation that has always historically welcomed immigrants. To change the story being told that it's not criminals and terrorists coming into our country, but people wanting to work hard and add to the fiber of our community. To welcome international students, welcome people from other countries for all they bring and contribute to our country, to have it look like a net gain instead of competition, right? With taking away US jobs and this very us against them mentality that's been pervasive these days, and show that it's actually a benefit for us economically, culturally, socially. And if we can change the narrative and bring that back, we have a much better chance at bringing in comprehensive immigration reform and seeing positive laws come into play instead of the restrictionist policies that we've seen lately.
Okay, with that, I think we have some time for questions. Amy, there was a question in the chat. I'm wondering if I can get things underway.
Yeah.
The question, and let me, it's simply, in a way, it's one of timing. That is, we're really under a lousy visa issuance situation, particularly for a number of countries where it's not outright banned, but there's simply a bias against things. How does that play into the timing? My own feeling and is that I think that it still makes sense and it's still timely, and we have had success in terms of getting J1 visas issued or H1B visas issued from countries that are not proscribed, but maybe have delicate or somewhat adversarial relations to the United States? Does it require, I don't think it's automatic. I think that it is incumbent to prep an individual what's required for a J1, the notion of non-immigrant intent, to build in and have the applicant be able to address and actually have in writing what's the benefit of his or her position at your institution, kind of a national interest presentation, which is I think really going to be quite important both at the consular level, carrying forward to the carrier that it's actually, the airplanes actually have been very stringent in making sure that they feel that someone can be admitted. And then at the final stage of admission through Customs and Border Protection. But I just don't see a particular logic, given so many things up in the air, to postponing unduly visa applications. Debra, you want to add anything? Or
yeah, I think part of it is just to be conscientious of that closures can happen. I mean, a lot of this is really just dependent on the public health of the area and community as well. And as we saw with travel bans, things can happen on very short notice. So what we saw, for example, when India shut down, all of a sudden it was very difficult to get out. Or what we've seen in Mexico, people who went home and their appointments keep getting postponed. And so we thought a 2-week is now 6 months. And so you just have to be able to balance those risks and take them knowingly. I mean, there's family you want to see, things you need to do, but that risk is just going to be inherent for quite some time.
Yeah. So if there's any further questions, we invite those at this time. But that looks like the only one that we saw. This is all of our contact information within ISSS. So you can see here, typically we work by portfolio in ISSS, especially at the Denver campus. Our colleague Christine Wen works with College of Liberal Arts and Sciences and School of Public Affairs. Anna Inazi, College of Engineering, Design and Computing, School of Education and Human Development, and Tyler with School of Business, College of Arts and Media, and College of Architecture and Planning. And then at Anschutz, Lana and I work with a lot of the cases out there. So we invite you, and Michelle also assists with our legal permanent residency cases. So we invite you to contact us with any questions that you have, as a result of this session. Anything that you'd like to discuss about extensions for any of your employees, or bringing in new individuals, we're happy to answer these questions. As Bob and Debra were saying earlier, the questions about incoming scholars is quite complicated at this time sometimes, but I can tell you that we have had a number of new J1 scholars come to the institution this year. So, we're filing H1b petitions. Debra is very busy helping us with our H1b petitions. So we are definitely, I've heard from a number of departments questions about, are you all still processing, visas as usual? And yes, we are. So please contact us with any questions.
Yeah, and I can also say, despite all the negativity we just told you about the rules, almost all of our cases are getting approved. I mean, so while we're up against maybe a higher threshold than a bar, we're meeting those. So don't be dissuaded from pursuing good candidates and individuals. We're still able to be very successful in our applications, and you have a great team at ISSS to help you through the process. And then if you want our contact information, there's ways to reach us as well, though we recommend you work through Amy to reach out to us with questions.
There's one more question here, Debra, maybe you can help with. Should we plan to pay for premium processing for H1b extensions?
I will say that should be really a case-by-case basis, because when you file an H1B extension, you are going to get a 240-day automatic extension of the work authorization while they're here. If you're doing a change of status, so if someone's going from J1 to H1B, for example, then we highly recommend filing premium processing, because there's no other way to expedite the application. There may be a gap in their employment. So that's one area when it's extremely important to do so. But otherwise, we're trying to file these as quickly as possible. And unless they have travel needs, I would say it's not always required.
Yeah, if I could just add one sentence, which Debra mentioned, one of the big determining factors is travel, which in a way is a little bit theoretical right now, but if you do travel, you need to have the approval in order to get a visa to come on back. So that would also be a factor for premium processing or not. But literally H1B cases, I mean, you're talking about 6 months or so, or it can be at that time frame. So as a realistic matter, I would say 80%, 90% are filed with premium processing, probably.
All right. Well, if there's no further questions, I'd like to thank Bob and Debra for presenting today. I really appreciated all the information. And please feel free to reach out to any of us with questions. Again, if you have cases and individuals that you're interested in, sponsorship for H1B or green card, please contact ISSS, and then we will reach out to Bob and Debra for assistance. All right, thank you. Thank you for joining us.
Thanks, everybody. What a pleasure. Thank you.